talk about the form of the exam? How it's going to work? Okay. My understanding, there's going to be 120 multiple choice questions. Of those, 10% are going to be on law and ethics. But there are 17 topics that they cover. So you can't cover all the topics every time. So we're going to cover all 17 topics, but you're only probably going to get, probably 10 sections are actually going to have questions. Sometimes they double up and everything. This is their listing of the questions. So what I've given you is one sheet on each thing. Take it, reflect on it, look at it, you know, whatever. But it's just, again, things that will hopefully jog your memory. Court systems. The local trial court in Georgia is called the Superior Court. So you've got local courts and you've got federal courts. The questions are probably going to be on the federal courts. And it's going to ask you, you know, the federal district court is the trial court. We then have the 11 circuit courts of appeal plus the DC circuit. So there are 12 circuits that you can then appeal to if you don't like the result of the trial court. And then one Supreme Court above that. You have a right of appeal to the Court of Appeals. You have no right of appeal to the Supreme Court. They have discretion to take or not take what they want to take as far as cases. Pretty simple structural lawsuit. The plaintiff starts the lawsuit by filing a complaint. Statement of facts, statement of injury, prayer for relief. The defendant, then depending on what court you're in, responds with an answer. Statement of facts, argument, prayer for relief, dismissal of the plaintiff's lawsuit, something like that. Once we get to that point, we enter into a period of discovery. Start with written discovery. Interrogatories, that means I send you written questions, document production requests, all sorts of things. Admissions. Will you admit the following is true? Yes, no. In federal district court, the normal period of time for discovery is 4 months. You can usually get one extension to 6 months, maybe 8. But most cases settle at the close of discovery because we all know all the facts by the time we get to that point. I know everything about your case. I have seen your witnesses. I have talked to your witnesses, but we get into oral discovery as well. That's depositions. So the terminology that you'll see. So 90% of the cases will settle at the close of discovery. Somebody will file a summary judgment motion. The function of the judge is to apply the law. The function of the jury is to determine the facts of a particular case. So if there are no facts in dispute, then the person who files a motion says, Your Honor, no facts in dispute, just apply the law, I win. If at trial either party does not get all at once, it can appeal. So either party can appeal the judgment. Even if you win and you think you didn't get enough money, you can appeal. If you lose, you can appeal. So, pretty straightforward. Constitutional law. The Constitution establishes the 3 branches of government, which are executive, judicial, legislative. And they all are in. We have what's called a balance of power. Everybody checks and balances. You will find in the Constitution what's called the Supremacy Clause. The Constitution is the supreme law of the United States. No state constitution can have anything that violates the U.S. Constitution. No federal legislation can have anything that violates the U.S. Constitution. Everything comes back. It is the supreme law of the United States. We have the Commerce Clause. The federal government, as a result of the Commerce Clause, is allowed to regulate any trade that crosses state borders. So interstate commerce becomes a big thing. You may get a question about interstate commerce. Where does the right come from? The Commerce Clause of the United States Constitution. You may get a question on the Bill of Rights. The Bill of Rights were the first 10 amendments to the Constitution. 5 years after the Constitution was ratified, the Constitutional Group got together again, and some people said, Well, there's some things that we would like to include now, and the other side said, well, they're implied already, and the other side says, okay, if you agree they're there, let's write them down. So they proposed 12 amendments, 10 of which were adopted and are referred to as the Bill of Rights. And I have not listed all these because some of them aren't used on it. But the first one, freedom of religion, freedom of speech, freedom of the press. Those are First Amendment rights. The right to bear arms, a Second Amendment right. No unreasonable searches and seizures, Fourth Amendment right. No double jeopardy, Fifth Amendment right. Trial by a jury or peers, Sixth Amendment right. No cruel and unusual punishment, Eighth Amendment right. Anything that's not in the Constitution is not regulated by the federal government. So if it's not there, and that's what 9 and 10 take care of. So the federal government does not regulate schools. It's not in the Constitution. The federal government does not regulate insurance. It's not in the Constitution. So those things are left to the states and left to the people. Administrative law. The legislature passes laws and then delegates to respective agencies the making of the rules and regulations. The federal government will pass a law like the Environmental Protection Act, but it can't enforce that law. It has to have an agency to do that. So that becomes the Environmental Protection Agency. That agency promulgates rules and regulations that interprets what's going on, what the federal law says. And it has the same impact and import as the law itself. So state laws can't overrule federal rules and regulations. We have what's called exhaustion of administrative remedies. There's a lot of administrative laws that say you can't go to court until you have exhausted all your administrative remedies. You must go through the agency first to see if you can get relief. Classic example is the Equal Employment Opportunity Act. Title VII of the Civil Rights Act prohibits race discrimination, among other things. Equal Employment Opportunity Commission is the federal agency that enforces the law. If you want to pursue a charge of race discrimination, you must file with the EEOC before you can ever go to court. The EEOC will investigate. They're not really concerned about the one person being discriminated against. They're concerned about systemic discrimination. Walmart discriminating against all women, something like that. And then they will take up the case. But the administrative remedy is, if you've got a claim of discrimination, you must file it with the EEOC within 180 days of the last act of discrimination. If you don't file, you lose your rights. If you file and the EEOC doesn't want to pursue it, they will give you what's called a right to sue letter. That's the exhaustion of your remedies. Now you can go to court. But you literally have to file that right to sue letter with your complaint and say, we've been there. So the big thing about administrative law is really the exhaustion of administrative remedies. You have to go back through the agency to get relief if you can. Tort law, it's easiest to tell you what a tort is not. It's not criminal, and it's not a contract, but it's anything else that results in injury to person or damage to property. It's an accident. Somebody runs into your car. You want them to pay for the car, that's a tort. It's a civil action to get them to pay for your car. A civil wrong, not criminal, although a civil action can follow a criminal action arising out of the same set of facts. The person driving the car was DUI. They get charged for DUI. You use that in your civil case. But typically, if there's ramifications that are both criminal and civil, you let the criminal case go first, and then you use whatever you get out of that for your civil case. Intentional torts. I knew what I was doing and I meant to hurt you. It was intentional. Unintentional torts we refer to as negligence. It was an accident. There's probably no criminal liability in those situations, but there are 4 things that you must meet. Misspelled reach. 4 things that you must meet to get relief under the Civil Tort Act. Establish that there was a duty, that duty was breached, that the person received an actual injury or damage to their property, and that I can make a causal connection. What you did resulted in this. duty can become a real question. You know, do you owe a duty in certain situations? A duty can be established by relationship, a duty can be established by contract, a duty can be established by a lot of different ways. Then we have some strict liability torts. The product you are producing is inherently dangerous, and we're going to go ahead and call it defective. So you had a duty to produce a non-defective product. You breached that duty simply by producing this product. It's inherently dangerous. What we're really doing here is saying we're going to shift the risk of loss. We're going to make sure you, the company, are the ones that buy the insurance. And you're going to know that up front. So strict liability torts. You probably remember this chart. This is a comparison of civil and criminal law. Civil law is between individuals. It's about harm or person to damage the property brought by the person that's harmed. Standard of proof is preponderance of the evidence. That means more likely than not. And what you get are damages. You can get some equitable remedies. You might get an injunction or something like that. But in most cases, the court will try to award you damages because they can enforce that. Criminal law side, the offenses against the state is the violation of a statute. The aggrieved party would be the people of the state. So whether it's the local district attorney, the state district attorney, federal prosecutor, those are the people who bring the case. Standard of proof, beyond a reasonable doubt. A very, very high standard of proof. And the remedies, you get a fine, or you get imprisonment, or you get both. We distinguish felonies and from misdemeanors by the potential penalty that you can get for violation of that statute. It's not what you actually get, it's the potential. Anything where the potential penalty is a year or more in jail or $1,000 or more in fines is a felony. Conviction of a felony carries with it all sorts of ramifications. You lose your right to vote, you lose your right to carry a gun, you lose all sorts of personal rights. Misdemeanors is anything where the potential penalty is less than a year in jail, 11 months and 29 days, or the fine is less than $1,000. Now, if I'm charged with a crime where the potential penalty is 5 years in jail, but I only get sentenced to 6 months, it's still a felony. Because it's the potential for what you could have been. The defenses, there are always defenses in civil and criminal actions. In the criminal action, we attack what's called the mens rea, the evil mind. Did you intend to do it or not? And so we always try to attack intent if we can. Employment law, there are probably three that you need to be particularly aware of. Title VII of the Civil Rights Act of 1964 prohibits discrimination based on race, color, national origin, religion, and gender. It does not protect you from discrimination on the basis of sexual orientation. There are some states that do that, but the federal law does not do that yet. It also includes two concepts. One about sexual harassment. Individual sexual harassment, I'm harassing a particular person, or I'm creating a situation in the workplace where there's this pervasive sense of sexual harassment, sexual discrimination. So I can have that on both sides. Age discrimination, you cannot discriminate against people over 40 in hiring or employment. So it's people who are your employees or who may become your employees. Americans with Disabilities Act prohibits discrimination against the disabled. That definition in the last few years has been widely expanded. It's a very large group. It used to be people who could not see, hear, walk, all sorts of, but now it's anybody who has any sort of impairment can be characterized as a disability. If you wear glasses and when you take your glasses off, your vision is less than 20/80, you're disabled for purposes of this act. And you can't be discriminated against as a result of that. Companies are required to give reasonable accommodation. If I can reasonably accommodate your disability, I need to do that. Because to prove that, you've got to prove that the only thing holding you back from doing the job is the disability. On top of that, we have affirmative action. This is also enforced by all these are enforced by the Equal Employment Opportunity Commission. We have affirmative action. That's the attempt to make present corrections for past wrongs. To let people come forward and say, my group was discriminated against. I lost an opportunity, therefore I need that opportunity corrected. It can be as a result of age, it can be as a result of race, it can be as a result of gender, it can be as a result of any of these things. So affirmative action applies to all these different things. Antitrust laws, there are 3 primary antitrust laws. Section 1 of the Sherman Act prohibits vertical and horizontal restraints. You can't keep people from coming into the market. But it does require conspiracy, which means it's 2 people acting against a third person. You get a conspiracy. You can't conspire with yourself. You have to conspire with another party, somebody outside your company, to harm a third party. So I've got to have that for a Section 1 violation of the Sherman Act. Section 2 particularly challenges monopolization or attempts to monopolize, however occurring. It doesn't matter that you didn't do anything. If you're in the market and you're a good producer and your competitors just keep dropping out and you wind up with a monopoly, you violate Section 2. Doesn't require conspiracy. It's just, however, we don't like monopolies. I think that's harmful. We have barriers to entry to the market. The Clayton Act was amended with what's called the Robinson-Patman Act to say that I must sell to people similarly situated at the same price so they can compete with each other. So I'm always encouraging competition. The Sherman Act and the Clayton Act and the Robinson-Patman Act are enforced by the Department of Justice. Then we have the Federal Trade Commission Act, which basically is the catch-all. It says anything anti-competitive is a violation of the law. It's kind of catch-all. Now, the Department of Justice reports, it's an executive agency and reports to the President of the United States. The Federal Trade Commission is a congressionally created agency. It's an administrative agency that reports to the Congress. So I've got these 2 agencies, one from the executive branch, one from the legislative branch, and they're trying in a lot of ways to cover the same things. Consumer protection, the Antitrust Division of the Department of Justice and the Bureau of Enforcement of the Federal Trade Commission. Antitrust Division of the Department of Justice is run by lawyers. The Bureau of Enforcement of the Federal Trade Commission is run by economists, dealing with 2 very different groups. So, enforce laws which enhance the quality and pricing of products in commerce. Advertising, that's primarily covered by the FTC Act. And the rule for advertising is, if you're going to make a claim, you have to have all the documentation for that claim in your file before you make it. The fact that you make a claim and somebody challenges you and you run out and run some tests and prove the claim is true doesn't work. You've got to have all the backup for the claim before you ever make it. Truth in lending, any bank who lends money or anybody who provides consumer credit, sells things on time, is covered by TILA, the Truth in Lending Act. And it's the effort here is to let consumers compare apples and apples, that the interest rates are the same or different or whatever they're there. Food and Drug Act, amended later to the Food, Drug, and Cosmetic Act, enforced by the Food and Drug Administration and some part of it by the U.S. Department of Agriculture. The U.S. Department of Agriculture reports to the President, the FDA reports to the Congress. Labeling and packaging, that will tend to be industry specific. Whatever industry you're in. If you're in the food industry, you've got very specific. If you're in the carpet industry, it's the Federal Fiber Identification Act. It's very specific about how you can label your carpet and what you can include. Magnuson-Moss Warranty Act. If you're going to put a warranty on your product, and you want to limit that warranty, the first word in the warranty must be limited. If you just put warranty and then limited anyway, no. The Federal Trade Commission and the Department of Justice will assume that a consumer is not going to read the warranty language. They'll either say, if it says full warranty, it's a full warranty, whatever a reasonable consumer will think it'll be. If it says limited warranty, now they're on notice. If it just says warranty, it's a full warranty. So if you want to limit your warranty, you got to put limited as the first thing. That's what we get from the Magnuson Moss warranty code. With any product sold in commerce, you get an implied warranty of merchantability that the product is generally suitable for the purpose for which most people use it. It's a very broad warranty. The other side of that is implied warranty of fitness for a particular purpose. I tell you what I'm going to use this for, and you know that it's not good for that or not suitable for that, then it would be reasonable for you to say something and stop me. So if in fact you don't stop me, then I get a warranty that in fact it's good for that. You know, I need a chain to pull a car. And I go into Home Depot and says, I need a 1/2 inch chain, I'm going to pull a car and everything. And the guy selling the chain knows that you don't need a 2-inch chain. 2-inch, you know, just pull. But he sells me the 1/2 inch chain. I go out, I pull the car, I get started on the highway, the car comes loose, it runs off the road. He's liable. Because a reasonable person would have said, when I told him what I was going to do with it, the particular purpose, he should have stopped. And warranty disclaimers, you can disclaim any warranty. It's got to be conspicuous, specific, and obvious. That's the test. Conspicuous, specific, obvious. Environmental law. The question you're likely to get is probably either going to be on NEPA or RCRA. But here are the basic federal environmental laws. National Environmental Protection Act enforced by Environmental Protection Agency or state agencies. The EPA may delegate enforcement of the federal laws to state agencies if they think the state agency is capable of enforcing it. They do delegate to the Georgia Department of Natural Resources enforcement of the environmental laws in Georgia. Tennessee, they have not delegated. They don't trust Tennessee to handle the environmental laws, so the EPA is very big up there. Regulated waste. Industrial waste is anything coming out of your plant. Water, paper, dirt, smoke, whatever comes out of your plant is waste, industrial waste. A subset of that is hazardous waste. Things that require some sort of special handling, and that's what's covered under RCRA. A subset of hazardous waste is toxic waste. Those are things that will burn you. Things that are used in the manufacturing process but are very dangerous. How do we know what's what? We have TSCA. The Toxic Substances Control Act tells us what waste we consider toxic. Last count, there were 74,543 toxic chemicals that you need to be aware are on that list and how they need to be handled. Okay. Hazardous waste, again, that's under RCRA. RCRA is the big dog here. This is the one you're going to have to deal with most likely to get some question on. Has to do with hazardous waste disposal, and it has to do with cradle to grave tracking. Whoever first has the spent chemical creates a manifest, a document. They give that to a transporter. So we have generators and transporters. They take it to a disposal operation. That person has to sign off on the manifest too. So there's a paper trail for all hazardous waste. And it's a bother. It's a problem, but you know they've got all sorts of things. We have CERCLA, which is Superfund. The government decided that they would take on the task of cleaning up hazardous waste sites rather than suing people and getting them to do it. They would go ahead and do it and then sue to get their money back. But what they cover with Superfund and the cost recovery is what are called potentially responsible parties. So everybody who's ever been a generator, a transporter, a disposal unit, anybody who's ever touched this chemical or owned the land on which it's on is now a PERP, potentially responsible party. So they don't just sue the bad guys, they sue everybody that ever touched the product. CERCLA had a 5-year sunset provision on it, that it would go away, because they thought they would have the problem handled in 5 years. Yeah, right. So now we have SARA. SARA reauthorized Superfund and includes with it now the community right to know. If you're a manufacturer and you have any chemicals that are either under RCRA or TSCA, you have to alert the local fire departments what chemicals those are so they know how to treat those if they come in. Because there's some chemicals that if you spray water on them, they explode. You can only use foam. You know, if you were to go to the Dow Chemical plant down here at Connector 3 and go in there, spray water on those chemicals, they vaporize, and then the first spark, they're gone. It's an explosion. So you use foam. You smother what's going on. You also have to appoint a particular person for each company to talk to the newspapers. And so lots of things that come under community right to know. I think Dr. Jones was talking to you about international business. But the international law concept, the first things you need to know about comedy, think the word accommodation is the same root. Deference to laws and decrees of another issue. The legal acts of a government taken within its own borders will be respected by all other governments. The legal acts taken within a company's own borders will be respected by all of it. You know, we're not going to tell you how to run your company. Maybe. Yeah. Exports. We've got several different ways of selling exports, selling our products to people in other companies. Direct sales, manufacture here, sell here, deliver there. Okay? Manufacture, it's direct sale. We have distribution, manufacture here, sell there, deliver there. We have licensing, manufacture there, sell there, deliver there, and collect a royalty back for teaching the people there how to manufacture. That's a license. You may run into things in the international legal construct that you don't run into here. One will be choice of law. If we have a problem, which country's laws will apply? It becomes a negotiating. You're dealing with a company in France, they want the documents in French and they want French law to apply. You want the documents in English and you want English law to apply, or American law to apply. It becomes a negotiating point. So you have the choice of language question too. The World Trade Organization also provides what's called most favored nation status. If you participate in the WTO and adhere to their various requirements and they are industry specific with the WTO, then you get what's called most favored nation status. Whatever the lowest tariff rate is for countries shipping those kinds of goods into other countries, you get that benefit. So it's a lower tariff is what you're getting. And that's an economic sanction. You know, if I deny you the lower tariff, it's harder for you to get your product into that other country. We have a question about foreign exchange rates. Whose money are we going to use? How do I relate that? How do I figure out how many dollars this and that? I know I've told you stories before about getting caught with people using what they call dollars. You go to Singapore, and a Singapore dollar, let's get this right, $1 US is worth 2 Singapore dollars. But so you got to keep that in mind when people are talking about things. Make sure you're talking about the right currency too. The U.S. does not tax exports. We can tax imports, and we call that tariffs. So taxes on goods coming in to the country, and we use that to protect U.S. companies, enforce the tariffs. The U.S. does impose export and import controls on certain products. There are certain things we do not allow outside the country. There are certain Cray computers that nobody outside the country can buy. There's certain software that people can't buy. And there's certain things that we don't want brought in. So we're going to prevent that too. Right now, there are a lot of drugs, cancer drugs that are available in Europe that you can't get here because they haven't been through FDA approval here. So, you know, you got things that people would like to bring in to sell, but we have controls on those products. Securities regulation. as a result of the market collapse in 1929, there was proposed federal legislation to regulate the markets, stock markets. The first of those is the Securities Act of 1933. It regulates companies whose stocks are traded on the markets, on the financial markets. So it regulates companies. The Exchange Act was passed in that year. It actually regulates the exchanges where the publicly traded companies' stocks are bought and sold. So think about the 33 Act. 33 Act regulates IBM. 34 Act regulates the New York Stock Exchange. Did you know the New York Stock Exchange was sold and is owned by a company in Atlanta now? Reporting requirements under the 33 Act. This is what a publicly traded company must do to comply with the 33 Act. Annual report on Form 10-K. It's an extensive document. It is a set form. You get no points for creativity with a 10-K. It is updated 3 times a year with a quarterly report called a 10-Q. So every company every year is going to have a 10-K and 3 10-Qs. The 10-K is due 45 days after the end of your fiscal year. The 10-Qs are due 30 days after the end of your fiscal quarter. In addition to that, if there is any material event that occurs that a reasonable investor in your stock would want to know in making a decision to buy, sell, or hold that stock, buy, sell, or hold, you have to report that on an interim report on Form 8-K. Big companies, they might be filing 2 or 3 8-Ks a week. In addition to all that, publicly traded companies are required to hold 1 meeting of the shareholders every year. And that annual meeting, they specify, the 33 Act specifies the things that have to be extracted out of the 10-K and the other things that have to be added to the proxy statement. So that annual report to shareholders has a set form too. One of the things that's in there is the auditor's report. Auditor's report signing the financials presented here in this annual report accurately reflect the financial status of the company as of a date certain. Bang. Somebody signs it. Because of Sarbanes-Oxley, the chief executive officer and the chief financial officer now have to sign a management letter that says the financials as presented in this report accurately reflect the financial condition of the company as of a date certain. Bang. And they sign it. And if they're wrong, they go to jail for 5 years. Puts them on what's called a duty of inquiry. You can't rely on other people to tell you that the financials are right. You got to check it out. There have been questions before on insider trading. That's when you work for a company and you have information that's not generally available and you buy and sell the stock. That's insider trading. And the definition again is anything a reasonable investor will want to know in making a decision to buy, sell, or hold your company's stock. So buy, sell, or hold. Contract law. 2 semesters in law school distilled down to 1 paragraph or 1 sentence. An agreement enforceable in court by and between 2 or more parties with legal capacity, supported by consideration for each party to do or refrain from doing some legal act now or in the future. Important parts are enforceable, capacity, consideration, and that's present consideration. I can't give you consideration for things you've done in the past, so it's party to do or afraid of something legality, now or in the future. You've got to have at least 2 parties to a contract, an offeror, offeree, or promisor, promisee. The offeror starts the negotiation, creates in the offeree several options: accept, reject, counter offer, inquire further. If they make a counter offer, the offeree now becomes the offeror, creates in the original offeror, now the offeree, the ability to accept, reject, counter offer, inquire further. 2 essential elements. This is in general contract law. An offer and a valid acceptance of what we call the mirror image rule. I must have accepted exactly what you offered. Consideration, something of value passing from the offeror to the offeree and from the offeree to the offeror. We both have to get something out of the transaction. If only one of us gets something, then that's a gift. So there's something back and forth. In the test materials, they call it sales law, but they're really talking about the Uniform Commercial Code. Article 2, Uniform Commercial Code. Contract for the sale of goods where the ownership of goods is transferred from a seller to a buyer for a price. A big part of what goes on is FOB shipment versus FOB delivery. And the question about if the goods are in transit, what happens, who's responsible, etc. You can contract for the goods to transfer from the seller to the buyer at the point of shipment or at the point of tender of delivery. If you don't say anything, then the UCC says it's FOB shipment. Article 2A, this is where the accountants got involved. And they said, well, we've got these things that are really not goods in commerce and everything, but they're leased goods and they really don't transfer ownership, but in fact you've got use and possession of the goods. So instead of creating what would have been Article 14, they just called it 2A. Lease contract, a contract by which the owner of the goods, the lessor, transfers the right of possession and use of the goods to another person in exchange for rental payments. The UCC assumes merchant-to-merchant transactions, not merchant-to-consumer transactions. These are expected to be two reasonable business people interacting with each other, both of whom want the deal to go through. UCC Article 3, negotiable instruments. Negotiable instruments are formal documents, formal defined as must be in writing to be enforceable. Article 2 and 2A facilitate the free flow of goods in commerce. Article 3 facilitates the free flow of financial instruments in commerce, and 99.9% of the time that's going to be a check. Got to meet 6 requirements to be a negotiable instrument. Must be in writing, must be signed. If it's a promissory note, it's the maker. If it's a check, it's a drawer. So assume drawer. Unconditional promise to pay or order to pay or to order. Just there's no conditions. This is, you know, it should be unconditional promise to pay or unconditional order to pay. Must state a fixed or determinable amount of money. If it's fixed, it's a check, it's a bearer note, something like that. If it's determinable, it's a promissory note where I have to sit down and calculate how much interest is due, but I can figure out how much. Got to be payable on demand, which means I can take it to the bank right now and put it in my bank account, or at a definite time, a promissory note that's due in 30 days, or 90 days, or 15 years, or payments over 15 years, but I can figure all that out. And it's payable either to order, and that should say or bearer. To order is payable to a specific person. To bearer is payable to anybody that shows up. There, on the exams, that questions I was able to see, there were actually 2 questions out of the 12 on business organizations. Okay? And they were not hard questions. 3 basic forms of business organizations. Sole proprietorship. You don't need any special filings. You can use your own social security number. You get all the profits, all the losses, and all the risk. This is a disfavored form of business organization. Partnership, shared control. More than one person running the company. They share the profits, they share the losses, and all the risk. Unless you establish a limited partner, then a limited partner limits their risk by giving up day-to-day control, and the most they can lose is how much they've invested in the company. You can't. The problem with a partnership is if one partner screws up and people get sued, they can all get sued. Corporation, shared control. I've got board of directors, I've got managers, I've got all those sorts of things. Limited or no risk. I've built a hedge. You can sue the company. The company is a person for all intents and purposes. It defends its own lawsuits, it files its own taxes, it does all those sorts of things. If there's something wrong, sue the company. You can't come after me as a shareholder for anything else. We have equity investors. Those are the people who actually buy shares. or we sell shares to them. We have what's called an LLC, and that is not a limited liability corporation. It is a limited liability company. It replaces what used to be a standard C corporation with a sub-S election for tax purposes. But it gives you full control of limited risk. This is the favored form of transactions for small businesses at the moment. Whether you're a sole proprietorship or a partnership, you're much better off being an LLC. If you want to be a corporation, that's okay. In fact, you probably got more protection as a corporation than you do as an LLC. But you don't ever want to be a sole proprietorship. The difference between being a sole proprietorship and being an LLC is a $100 filing fee and getting a new tax ID number. Just need to do that. Agency, principal and agent, but the primary form of agency agreement is employer-employee. So if you think of that in those terms, it may help them. An agent is always liable, and under certain circumstances, the principal may also be liable. You're driving your car on company business, you hit somebody, you're liable. But your company may also be liable, and in fact may owe you some duties. A disclosed or partially disclosed principal is liable to a third party for a contract made by an agent who is acting within the scope of his authority. If you know that there's a principal out there. If the agent exceeds the scope of authority and the principal fails to ratify the contract, the agent may be liable. The principal may not be. Each party is liable for his or her own torts and crimes. Principal may also be liable for agent's torts committed within the course of employment. Principal is liable for an agent's crime if the principal participated by conspiracy or other action. If you're an employee of the company and I sent you to a meeting where they engaged in antitrust violations, you're personally liable. And the company's liable too. The difference is you'll go to jail and they pay a fine. But the primary principal-agent relationship is employer-employee. Intellectual property comes in three forms. The most difficult to get and the most useful are patents. The right to own and practice a new novel, non-obvious invention. We want to reward the inventor. And everybody who participated in the invention is an inventor. I can have 2, 3, 4, 5, a dozen inventors on any patent. But I'm trying to reward them for what they've done. Trademark. A mark on the actual product to indicate the manufacturer of the product. It is not a trade name. A trade name is the name of the company. Trademark is on the product. There are some products on which you can't put a mark, so we have there what are called service marks. I'm delivering a service, but you have the same rights as a trademark. You can register it the same way. The easiest to get and the least useful is a copyright. Basically, I send the 2 copies of what I want to do with a 1-page application and a $75 fee to the Library of Congress, and they register the fact that I have written this as of a certain date. But if somebody comes and challenges it, or does that, they don't offer me any protection. Copyright's the right to control reproduction, i.e. copies, of tangible works, including writing, songs, designs, anything. Tangible means I got to be able to touch it. I can write down a song. I cannot trademark a sound. I think I mentioned this in class. The only time I'm aware of a lawsuit, Harley-Davidson attempted to get a trademark of the FLH 74, that's the 1200cc engine, going from 0 to 60 miles an hour in 5.6 seconds. It says it's distinctive, if something marks us, nobody else can do this, and everything. And the judge just said, no, can't trademark a sound. I'm not going to do that. So it's got to be tangible. Ethics, you may be asked to distinguish between deontology and utilitarianism. Deontology, duty-based ethics, often arising from religious source or a sense of duty, that noblesse oblige. I'm responsible for taking care of other people, so I'm going to, I have that ethical norm. As opposed to utilitarianism, ethics based on what achieves the greatest good for the greatest number, even if some are harmed, may require a risk-reward analysis. I'm going to do what's going to benefit the most, even though some minority groups may get hurt. Greatest good. It's utilitarian. Business ethics, the application of ethical philosophy to business. The big study is philosophy. Subset of that is ethics. Subset of that is business ethics. So applying ethical constructs in the business world is what we call business ethics. And the purpose, help business people begin to identify ethical issues, recognize approaches available to resolve them, learn about ethical decision-making processes, try to get you not to recreate the wheel. There are people who have seen situations before, and you get to see how they've dealt with it. Now, that's the list of 17. The next thing here are some questions from prior exams. And this is how they're going to look. And just for your ease of learning, every answer to these questions is D. Because I want you to read all the way through the answers. Which of the following statements about the tort of negligence is true? It cannot be used as a basis for liability for defective products. That's true. It is a strict liability tort with no tort of negligence. No, that's not true. Requires proof of some intentional conduct. No, that's negligence. Requires proof of breach of a statutory or common law duty. Remember, it requires 4 things. Duty, breach of duty, actual injury, causal connection. Got to have all 4 of those. So it does require breach of a statutory or common law duty. Which of the following would most likely occur as a result of the United States government's imposing tariffs on foreign steel imports? Employment in the United States steel industry would increase. Government tax revenue would fall? You don't know. Price of imported steel in the United States would decrease? No. Price of steel produced in the United States would decrease? No, it'd go up. So what's going to happen? The one thing that's true here is employment in the United States will go up. Now, I'm not sure why they called that a legal question, but they did. All of the following are true regarding a seller's rights to reduce legal liability in the sale of non-consumer goods, except the seller can disclaim consequential damages if done clearly and conspicuously. You can always disclaim. Seller can limit the remedy available to the buyer if she does so clearly and fairly. You can write into your contract and say, your only remedy is to get your money back. And if you sign that, that's the remedy. Seller can place reasonable conditions on the warranty coverage and a shorter time limit on of warranty coverage. Yes. Seller can disclaim all implied warranties by simply stating there are no implied warranties. No. The reason is because the implied warranties are implied in statute and you get those no matter what. They're not part of your contract. Okay, so you can't disclaim what's not part of your contract. Green desires to form a new company to manufacture lawnmowers. Green is concerned about having personal assets exposed. Okay, so he does not want to be a sole proprietorship or a partnership. For the new company's contracts and torts. Furthermore, he wants to retain control of the company's operations. He doesn't want a limited partnership. He will need an infusion of equity capital. That means he's going to sell shares, and that's the key statement in this question. Equity capital means I'm going to sell shares. He hopes to take the company public in about 5 years, if it is advantageous to do so. Which of the following types of business associations would be best for the company? The only one that fits is corporation. Because that's the only one you can sell shares. Next question. When a domestic firm permits a foreign company to manufacture and sell its product in exchange for a fee or royalty, that process is called licensing. That's just what it is. I don't even know what counter trading is. Okay, they threw in a term I've never seen. But it's not importing and exporting, it's licensing. It's manufacturing there, selling there, getting payment there. And I thought this was a cute question. It will be the things. Family branding refers to a group of similar brands of products from different makers. That wouldn't be a family. Different brands of products from different makers within the same industry. No. Similar products sold by small family-owned firms. No. Different products marketed under a single brand name. And the example is Chef Boyardee. Spaghetti and meatballs, ravioli, macaroni, all under the same mark, all related, all under a single brand name. That brand name is the trademark. So I guess that's why I call that a trademark question.
Okay, I was just asking.
Okay. You've seen the form of the exam and the form of the question, and you now have the 17 potential topics. What questions do you have? There can't be. Go home.